Yes, Mr. Craig.
My Lord, if it's convenient, it's probably time to turn to the case of Walters to address our submissions on that case.
Sorry, I didn't hear which case.
Walters, the case.
Walters, yeah.
Tab 10. This is the case which we've just seen Lord Dyson deal with in Taylor and Novo. Distinguish it on the basis of it being the question of whether the death being a separate event was the relevant event, not arising in Walters. The overarching point about Walters is that it was a case all about shock. It was not a case about an argument about what, no one was arguing about what the event being examined was. That was the fit involving the baby and what happened thereafter. The real issue in that case was the event to be a fixed or frozen moment in time, or could it be elongated to 36 hours to encompass a series of events, as the claimant was seeking to do, because shock was not, was as a result of that 36-hour period of treatment, ups and downs, reassurance, and then terrible news and the baby dying in her arms. If I can take you to page 324 of the authorities bundle, which is paragraph 2 of the judgment of Lord Justice Ward. This is where we get the facts. Now, from the judgment, it's not clear precisely when the baby went back to hospital after initial treatment in September 1995. It says 10 months later. He became unwell in line 2. But it's common ground between the parties, and my learned friends Paul have brought a copy of the first instance judgment if we need to look at it. But it's common ground between the parties that the baby went back to hospital on the 17th of July, and the fit occurred on the 30th of July. And the failing in that case was that the hospital failed to diagnose that the baby was suffering from acute hepatitis, which led on to liver failure. He wasn't properly diagnosed or treated, and if he had been properly diagnosed and treated, he would have undergone a liver transplant and would probably have lived. He was allowed home at weekends, 4 lines from the bottom of that paragraph. But on the weekend of the 26th of July, he was brought back to the hospital by his parents because of their concerns for him. He was a very ill baby. And his condition then deteriorated. The next paragraph, paragraph 3, until the morning of the 30th of July 1996. And the claimant woke, was with him in hospital, woke up about 3 a.m. To observe that he was choking and there was substance coming out of his mouth and he was stiff, and it was identified that he'd had a fit. And without doing less than justice to the detail of the case, initially the mother is given false reassurance that the child is not seriously unwell. Then further tests are done and there's a transfer to another hospital, and the mother is told, in fact, the baby has sustained a catastrophic brain injury, unsurvivable, and is shocked obviously by that news as well. And then tragically the baby dies in her arms 36 hours after the fit. So moving on to page 329, please. In paragraph 13 of the judgment, but paragraph 33 of the Judge Below's judgment. This is Justice Thomas. 4 or 5 lines down. Although the psychiatrists are agreed that she suffered shock and I'm satisfied her mind was violently agitated, the question is whether what happened was a sudden appreciation by sight or sound of a horrifying event, rather than an accumulation over a period of time of more gradual assaults on the nervous system, that it was that sudden appreciation that caused the pathological grief reaction. So the law, of course, makes a distinction between cases where there's a sudden and horrifying shock, a sudden event, and something which is in the nature of a gradual assault on the nervous system, which can cause the same end result of a psychiatric injury, but by a different mechanism. The law requires in secondary victim cases the former, not the latter. So that was what the case was all about. Had that shock in law test been satisfied, and was that what caused, was it sudden appreciation of that caused the pathological grief reaction from which the claimant was suffering? It's important to look, if I can take you on please to page 331. What the grounds of appeal were in that case, the claimant having won at first instance and the defendant appealing, because it's illuminating about what the court had to consider on that occasion. And the appellant's case was essentially this. It says in paragraph 19, the judge erred in law in holding that the 36-hour period could properly be held in law to be one horrifying event. Secondly, the judge erred in holding that the claimant's appreciation of that 36-hour period was sudden within the temporal context in contradistinction to a more gradual assault of the mind over a period of time. And there was an allegation that the judge had expanded the control mechanisms without sufficient regard to innovation. So the focus of the attack on the judgment was also very much the shock in law. No suggestion there by the defendant that there was an issue about the event. It was focusing on could it be elongated, because this was the first time this question was being looked at by the Court of Appeal, to a period of 36 hours. Could that be one horrifying event? And could a 36-hour period be sudden within the context of the requirements? Moving on then, if I may, to page 332, the next page, paragraph 20. Lord Justice Ward sets out 4 lines down. The real and only issue in the case was whether her illness had been caused by shock, and then for which the test which he sets out. Given that paragraph 21, given that common ground, it's unnecessary at this stage to examine the law in much detail. So it's interesting that Lord Justice Ward did not carry out, in my submission, the sort of detailed analysis and exposition of and consideration of. He set out the Alcott case and the control mechanisms, but by that observation we can see that it was deemed not necessary, because of the common ground, to look at the law in much detail, because the focus was very much laser-like on the question of shock in law. Then if one moves on, please, to the page 333 and the end of paragraph 23. In that last sentence citation there, the shock must come through sight or hearing of the event or its immediate aftermath. What was being said there was Lord Wilberforce was not intending to confine the event to a frozen moment of time. So the focus was all, again, on that elongation of the event or not. 336, please. Paragraph 29, Lord Justice Ward has a look at the case of Sion. The claimants in this appeal say, well, because Sion was cited to the court, they had in mind Taylor and Somerset, even though it wasn't specifically cited to the Court of Appeal in this case. Well, this is the passage where Sion is looked at, and there's no mention of Taylor and Somerset or the observations of Lord Justice Peter Gibson with regard to Taylor and Somerset, that he recognised the argument but didn't accept it. It's the focus on a separate point that Lord Justice Peter Gibson was making. Then moving on to 338, please, paragraph 33. Mr. Weir, for it was my learned friend who was appearing for the claimant respondent in that case, submits that it's clear from the authorities, in particular McLaughlin itself, the event can constitute more than a single moment in time. So that was the opposition to the appeal, that was the response to it, was saying you don't just look at one single event, it can be more than a single moment that can make up an entire event. That's important, I say, in that context. Further down that paragraph, halfway down, there's a sentence starting, the entire event can be made up of one or more discrete events over a period of time. And then final line, referring to observations of the trial judge in the Frost case. Justice Waller dealt with the case on the basis it was the horror of the whole experience which caused the rescue of psychiatric breakdown. That's important context because it puts, it explains the observation in the first paragraph, paragraph 34, which is the key paragraph ratio of the case, where Lord Justice Ward opens by saying, in my judgment, the law as presently formulated does permit a realistic view being taken from case to case of what constitutes the necessary event. Because it would be wrong to suggest that was being talked about in the context of selecting an event amongst a selection ranging from the first manifestation of the injury to something which is hidden and symptomless or some later consequence. That the court wasn't concerned with competing arguments about what the appropriate event was. The court was concerned with competing arguments about how long could the event be. Could it be longer than a single snapshot? And that's what Lord Justice Ward is talking about when he says a realistic view about what constitutes the event, what can make up the event, not what is the event. And that's, again, confirmed in my submission by what the judge goes on to say in the fourth line as a word, it has a wide meaning shown by the concise Oxford Dictionary as an item in a sports programme or the programme as a whole. So he does observe that it's a useful metaphor for Lord Wilberforce's fact and consequence of the defendant's negligence, the series of events which make up the entire event. But then he says, importantly, beginning with a negligent infliction of damage through to the conclusion of the immediate aftermath, whenever that may be. So the judge is looking at this from the sense of, can we encompass all that the claimant relies on to make good causation for her psychiatric injury by looking not only at the fit at the beginning, but the subsequent events as being all part of one event. But in our submission, the use of the term negligent infliction of damage is important because it makes clear that the event is starting with damage being inflicted on the primary victim. It is not starting with the consequence of some earlier infliction of damage becoming evident. So we would dispute the suggestion that this lends support to an argument that if one is proximate to that first manifestation, that is sufficient. This was a one-event case where the court was saying the moment of the fit was the infliction of damage, and thereafter there were a series of events, as the judge goes on, an inexorable progression from the moment of the fit as a result of the failure properly to diagnose and treat the baby, causing the fit, causing the brain damage, and shortly thereafter making termination of the child's life inevitable. A seamless tale with an obvious beginning and equally obvious end. It was played out over a period of 36 hours, which both at the time and subsequently recalled was one drawn-out experience. So again, the judge is focusing on the duration of the event, not the choice of the event. But I'm focusing for a moment, if we really need to, because it seems to be part of the claimant's approach to supporting this, the cases here, on the negligent infliction of damage. If one looks at that in common parlance, if someone is punched in the face, that is the negligent infliction of damage. That is the breach of duty. The negligent infliction of damage is not when the black eye comes up the following day, or when an x-ray is done and there's a broken cheekbone. If someone asked that person when they went to hospital, when was the damage inflicted on you, they wouldn't say when I saw I had a black eye, or when the doctor looked at an x-ray and I had a fracture. They'd say when someone punched me in the face. So in my submission, this is looking at the fit being the infliction by the defendant of damage. And it makes sense in a case where we were concerned distinguishing it from these cases where we are in the hospital setting. We do have a baby which is being is actively in hospital under clinicians, an ongoing duty to that baby in terms of the hospital's interaction with it. None of the features of this case where there's the individuals are outpatients. And that would explain why that continuing duty is then impacted on the baby by the happening of the fit. That's the proper explanation, if there is to be any connection. So I say this case is some distance in terms of any points it makes from the circumstance of this appeal. It's not a case about proximity in the legal sense. It's not a case about proximity in the factual sense. It is a case about shock in law, and it's not a case about if events have any relevance at all, if that's to be said, where there was a need to select between competing events, whether that was the first consequence for an individual, or whether it's when the damage becomes evident. It didn't consider any of those points, and it didn't look at proximity in its wider or its narrow sense. So it doesn't provide any assistance to the resolution of these appeals. And one does have to be very careful in my submission about drawing conclusions from a case which is not concerned with the point at all, that just happens to be a secondary victim claim, and saying, well, because that point wasn't argued in that case and wasn't taken, somehow it provides support for that argument not being a valid one. And the correct way, well, if one is having to compare, obviously I would say, as I did earlier, that this case, if one looks at it from the different perspective of it not being a one-event case, if there was earlier damage and this is the later consequence, it must be wrongly decided based on Taylor and Somerset and its endorsement in Taylor and Novo. But if you're against me on that, and this case does provide any assistance at all, the court will have to choose between this case and Taylor and Novo. And that, in my submission, is not a complex decision to make, because you have a choice to make between a case which is 10 years before Taylor.
Is that correct as a matter of the law of precedent? If you have two inconsistent decisions, but the second one expressly considers the first and analyses it in a way that isn't inconsistent, whatever we may think, aren't we bound by the second one?
Well, you are bound by the second one, yes. That's
Well, so you're saying we would have to choose between them?
well, that's my fallback position, really.
Oh, I see. I didn't realise you'd made the first one.
Clearly, but my primary position is Taylor and Novo is the complete answer. But if one needs to look at these decisions, my Lord's point is correct. But also, if there is any sort of weighing up to be done, then one should have no hesitation in preferring and following the decision which actually deals with proximity in law, which actually deals with proximity, factual proximity, and which actually considers the point relevant to this case, not a case which says I don't need to go into the detail of the law because the common ground is if this is a case about shock, only concerns itself with shock in law, doesn't cite the case, the clinical negligence case on which Taylor and Novo is decided, and is decided 10 years before Taylor and Novo itself, which, as my Lord points out, did consider this case and consider that it didn't derive assistance from it.
Well, as I understand the position, Mr. Baggett, there are 3 exceptions to the rule in Young and Bristol Aeroplane. And the first is that the Court of Appeal can decide which of 2 conflicting decisions of its own it will follow. So the first question is, are these conflicting decisions? The second exception is that the Court of Appeal is bound to refuse to follow a decision of its own which cannot stand with a decision of the Supreme Court. And the third exception is that the Court of Appeal is not bound to follow a decision of its own if given without proper regard to previous binding authority. So those are the 3 exceptions. It's not quite as simple as saying we're bound to follow the later of 2 decisions.
Yes. Well,
Accept that?
yes.
So you don't accept what I put to you. But you were probably right not to.
My Lord, yes.
But do you say the decisions are conflicting?
Well, they are in the sense that well,
I thought you said they weren't a few minutes ago.
You can distinguish. The easiest way to deal with it is to distinguish this case because it doesn't deal with the point at all.
I mean, I think your submission is that they are not conflicting decisions. That the decision of Walters was a case about whether there was, whether the loss was caused by shock, and the distinction that Lord Dyson drew in the later case, whose name's gone out of my head for some reason, Novo, was a perfectly valid distinction.
Save that Lord Dyson endorsed Taylor and Somerset as the basis for his decision in Taylor and Novo. And as we've seen, Taylor and Somerset says, in the passage which was endorsed by Lord Dyson,
You're looking at gift horse in the mouth. The Lord has put to you a proposition which gets you home and you're not agreeing with it.
well, I am agreeing with it, but I'm trying to cover off other arguments that might come later.
Okay. Well, let's
Perhaps
get to those when we've heard the arguments, shall we?
Exactly, I'll deal with that point. I'm conscious of the time. We've run over slightly over our estimate, but I don't think we'll need to detain you for much longer, or that Miss Jones will need to. But I want to touch on a couple of other points in the judgment of Mr. Justice Chamberlain, if I may.
Well, you haven't actually dealt with it, have you?
Yes, well, I hope I've touched on some of the criticisms of it, but I want to look at some of the detail of that judgment, if I may. If you have in the bundle, or the core bundle, page 208, which is the start of the discussion.
Can we deal with paragraph numbers?
Yes, paragraph 58 to 60. Here, if I understand it correctly, Justice Chamberlain is trying to make a distinction between looking at the control mechanisms as concepts and then their application at what he describes as the micro level to a given set of facts. And there's no reason to favour a conservative posture, nothing to inhibit the courts for aiming for maximal coherence. In my submission, that distinction which he's seeking to make has led him into error because it seems to have encouraged him to look for a way to find that these claims are arguable otherwise than by a strict application of the control mechanisms and the requirement for there to be legal proximity, a question which he declines to accept as the overarching question later in his judgment. So my submission is that it's a distinction without a difference, looking at the overarching control mechanisms, the requirement for legal proximity, and the determination on a set of facts. They are one and the same thing. And if it's being said that a less conservative approach can be taken to the latter, then that is an error, because we're in a territory of law where there is a requirement to provide, to apply strict control mechanisms which limit expressly the class of claimant that can recover. So there will be meritorious claims otherwise which do not succeed by reason of failing those particular requirements. In paragraph 61 on page 207, Mr. Justice Chamberlain references the argument that I made before him about the importance of the overarching requirement to show proximity between a claimant and defendant, but said that that appeal to proximity and that didn't assist. And again, the failing that Mr. Justice Chamberlain made was to not pose that question to himself. He didn't ask or answer the Taylor and Novak question, is there a duty of care at all, which is the key.
I think that's unfair to him. I think he did, but he thought it was answered by looking at whether the control mechanisms were satisfied.
Yes, but he did that also by looking at particular events. He fell into that error in my submission that Lord Dyson cautions against, of focusing on events, because he then, if one looks at the next heading, says what can count as an event, and is looking very much through that prism rather than is there legal proximity here at all, and he never actually answers that question. My submission, had he done so, he would have found, in line with Lord Dyson's observations in Taylor and Novak, that to stretch proximity to months or years was going too far.
Well, it's what I put to you earlier. He says virtually expressly that the proximity question, the legal proximity question, is answered by the control mechanisms. And therefore, if the control mechanisms are satisfied, the legal proximity question is answered. And you say that's wrong. There is an additional requirement of legal proximity, and that is the relationship between the claimant and the defendant, which is absent here.
Yes, but also, of course, I do say that the proximity, the factual proximity question also has to be answered in the negative here, because there's no event at all under Taylor and Somerset to which that test can be applied. So both of those questions lead to the same outcome. His focus on the events here really leads him to distinguish away from the considerations he is applying. If one looks at the bottom of paragraph 63 on the top of page 208, it leads him to consider that he wasn't affected or bound by what Lord Dyson was saying in Taylor and Novo about the focus on the collapse of the racking boards being months or years beforehand. He wasn't looking at that and grappling with that question at all. He then, at paragraph 66, is looking at the question of when the tort becomes complete and whether the first manifestation of the breach of duty is sufficient. I think you have my submissions on that point, but what I say is that position would bring in a new and separate regime for secondary victim claims.
Sorry, paragraph. Which paragraph would he had?
Paragraph 66.
But he's not saying anything there. Is he just? Or have I missed it? Oh, I see. No, you're quite right. I thought he was just reciting your submission, but he does begin to address it towards the end. Yes.
Yes, and then he
Sorry,
carries on addressing it after that. And really says that the first manifestation, it would bring in a regime where the first manifestation of an injury is the approach taken in secondary victim claims, whereas in primary victim claims the position would remain, and all injury claims, that one looks for actionable damage. That's both incoherent, but also would give rise to a range of difficult problems of how to resolve those questions. If one looks at the situation of where a relative, where something becomes evident but is not witnessed by anyone, would that be sufficient to be the stopping point? One looks at the situation where different relatives see different things becoming evident. Do they all have a claim, or is it only the first one? And if it's not, one can't identify which was the first, do none of them have a claim? There are all sorts of difficult and unprincipled factual considerations which would arise from that sort of formulation when the legal position of actionable damage, long established, where there's something that's more than de minimis, and when that was reinforced in the Supreme Court in Dryden, no one was suggesting that gave rise to impossible questions of fact or to resolve how that was to be determined. The bottom of paragraph 75 on page 213, paragraph 74 first of all, the judge is seeking to confine what Lord Dyson is saying to paradigm accident cases, but the fundamental difficulty with that observation is that isn't what Lord Dyson actually does. He's just simply giving an example, but also Lord Dyson has reached that conclusion based upon a clinical negligence omission case in the form of Taylor and Somerset. So that can't be suggested that principle somehow, he's made a choice between Sion and Taylor and Somerset and has declined to follow Sion and has said that Taylor and Somerset is correctly decided and adopts it. So this can't be seen as some narrow formulation. And also we know already, and it's common ground between us, that different principles do not apply to different classes of secondary victim claims. So that is not confining that concept to purely accident cases is not a formulation which is open on a proper analysis of the principles. Finally, the judge the judge then at the bottom, paragraph 75, really says, well, it doesn't matter that it's not an accident in the ordinary sense, but an event internal to the primary victim that's gone on before. It was the first occasion when damage is caused, but that's difficult because the judge was operating on the basis that there was no actionable injury in the Paul case, where that's now accepted by the claimants that there was actionable injury prior to the heart attack. So the judge was operating on a false premise there. The judge finally goes on to look at the question of what if there was some actionable damage prior to the collapse. And paragraph 78 seeks to apply a gloss which is nowhere to be found in the authorities in my submission, by saying, well, even if there was actionable damage before the heart attack, that still doesn't make this claim unarguable, because there wasn't something that could be properly described as an event that was witnessed by the secondary victim. That's not and that if there has to be that stopping point, it should be that when it first becomes manifest. But that gloss that is applied to say even if there's actual damage, it's not in the nature of the event. My submission has no support in the authorities. One is looking for the point at which one has the fact and consequence of the negligence, not some particular threshold type of event. Paragraph 81, the judge, this is where we criticise the judge for essentially, we say, impermissibly relaxing the factual proximity control mechanism, but saying that's satisfactory because it will still be necessary to establish the event was sudden, unexpected and shocking in the relevant sense. Essentially, the judge is saying that the other control mechanisms will still be a brake on claims. That, in our submission, falls foul of the requirement in the House of Lords authorities to apply all the control mechanisms with a strict approach and not to make adjustments to the factual proximity control mechanism, or indeed any of the control mechanisms saved by the operation of Parliament in any sort of substantial way. Lords, in addition to the arguments we put in our skeleton arguments, those are the legal bases on which we say that the judge fell into error. We say the master was right in this case to identify that Taylor and Somerset and Taylor and Novo were the direct answer to these cases. The cases were unarguable, or not more than merely arguable, in the light of those authorities, and the master was correct to strike out the Paul case, and that the judge, by overturning that strikeout, did so impermissibly. The only way that he could do that, which was by failing to address the question whether there was legal proximity and answering that question, and by addressing the factual proximity question, which was also a necessary question to answer, in a way which impermissibly relaxed that control mechanism, and went on obiter to make observations about the necessary point at which proximity would effectively cease, and did so in a way which endorsed the first manifestation of injury theory, which has no support in the authorities and rides roughshod over the coherence of the law by introducing a separate regime for secondary victim claims, not consistent with actionable damage being a de minimis threshold, which only requires something which is symptomless and hidden, but which is makes physical changes to someone which are more than minimal. Lord, I'm going to, with your leave, invite Ms. Jones to follow on, but before I do so, can I just turn my back for a moment?
Yep.
My lords, unless there's anything else I can assist with at this
No,
point.
thank you, Mr. Baggett. Ms. Jones.
Thank you, my lord. My lord, I'm going to keep my oral submissions relatively short. The appeal in the case of Polmear is heavily dependent on the correctness or otherwise of the decision of Chamberlain, Mr. Justice Chamberlain, in relation to which Master Cook held that he was bound by that decision and the reasoning in it. There's little point in me rehearsing the reasons that we dispute that now. The structure of my oral submissions, if I may, are a couple of preliminary comments on proximity, and then a summary of the facts of Polmear and where they're found, the four main findings of the Master in his first instance decision, and finally the reasons we say in summary that they are wrong where they depart from the reasonings in the Hall case. My lord, in relation to proximity, first of all, and really in light of the discussion prior to the short adjournment today, all these three cases conjoined in this appeal need to provide an arguable duty of care, having been owed to the secondary victim by the defendant. That is common to all three. And I come back to the two meanings of proximity explained by Lord Dyson in the Taylor and Novo case. See if I can put it in a slightly different way with a slightly different gloss on it. But it is clear that there are two meanings of proximity. The first one, legal proximity. That is a concept which, of course, is common to all tortious claims. It's the Donoghue and Stevenson neighbourhood principle, or the principle of directness. And it is the overall legal test where there is a duty of care or not. We then have the secondary meaning, the factual proximity test of the control mechanisms, which is discrete to the law of secondary victim claims. And the important part, which I think with respect your lordship has got, the second meaning, meaning two, is part of meaning one. It's one of the control mechanisms in a secondary victim case for determining whether there is legal proximity. But it's not in and of itself the end of determination of the proximity.
So what is? What isn't?
The second, the factual proximity test, isn't the end of the story, if I can put it like that. It has to be satisfied to move on to the general legal proximity case because it's one of the control mechanisms, all the control mechanisms.
But what's one of the, sorry, I haven't understood what's one of the control mechanisms?
The factual proximity question, temporal and spatial proximity.
Oh, you mean temporal and spatial?
Yeah, that's the factual proximity case. As one of the control mechanisms, you have to be present and hear by sight or sound the shocking, horrifying event. No good it being reported to you or so forth. So in some cases, satisfying the second proximity test may be enough. By way of example, if you have a relative or close friend present at the time of a breach of duty who suffers shock and psychiatric injury from perhaps watching a devastating outcome to the primary victim in hospital or elsewhere, and having been present and directly affected in the sense that the doctors treating the patient, perhaps negligently turning off the ventilator, resulting in a shocking, dramatic, horrifying death. That may be sufficient for proximity to be satisfied in both senses. But further down the line, if I can put it like that, a relative or close friend present at some later event, lacking the immediacy of witnessing by sight and sound a shocking, horrifying event. Distance from the breach of duty when that event is sufficiently shocking to cause injury by months or years may be a consequence of the earlier defendant's negligence, but it cannot properly be said to be the fact and consequence that is required by Lord Wilberforce, and it doesn't permit the secondary victim to claim. So, if you're looking at the special constraints limiting specifically the category of secondary victim claims, rather than the category of primary claims and so forth, the distance from the breach of duty further down the line, even if there is a subsequent horrifying sudden event, and it is assumed in all three cases for the purposes of this appeal, as it is pleaded as such, that that is satisfied, there is still the problem for the secondary victims of the remoteness, the distance from the breach of duty, meaning that it is too remote and too distant and insufficiently proximate in terms of the relationship between the tortfeasor and the claimant to allow the secondary victim to recover.
And can I get this clear, Ms. Jones, you're basing that solely on time?
On time and distance from the breach of duty.
What's the difference between time and distance there?
Well, it's temporal time. It's in a wholly different setting from witnessing a shocking event in the site, the scene of the duty of care. But the time is in the secondary victim cases. We've just seen from Walters. We're talking short times. This is the old-fashioned nervous shock claims originating in immediacy in the Hillsborough Stadium injuries. What the claimants are doing are seeking to transport that immediacy of injury far down the line in terms of months,
Yes, but what's wrong with them doing
days and decades.
that? What's wrong with them doing that?
Well, what's wrong with saying that a shocking event can last for a week? It was
Well,
very
that's a
much...
completely different question. If a shocking event happens absolutely immediately with no distance of time, if the shocking event is witnessed immediately with no distance of time, why is there a problem that it happened a long time after the breach of duty?
Because it goes to the question of foreseeability.
No, it doesn't. It can be equally foreseeable.
Not foreseeability with respect, it's
Well,
proximity.
you said it goes to the question of foreseeability. That's why I was picking you up on it.
It's proximity in the legal sense. And whilst that may not be a problem with the immediacy of the scene, witnessing the breach of duty and its immediate consequences, it will, in my submission, be far more difficult and impossible for the claimant.
I understand that, but I don't understand why.
Well, that is the approach the secondary victim claims to.
Well,
narrow
only in
the
Taylor and
claims
Novo,
to
in no other case.
Sorry?
Only in Taylor and Novo, in no other case.
Well, I don't think there was any other case that considered a time as far as 3
Exactly,
weeks.
that's my point.
Yes, absolutely. So that
This
is the
case really
that-
turns on whether Taylor and Novo. You don't get any help. You can't say this issue is decided by the earlier cases.
No,
It's decided-
absolutely not.
Okay, well that's fine.
Absolutely
That's
not.
all I was trying to
Yeah,
get at.
absolutely not.
Right.
No, it's Taylor and Novo square on, which
Yeah,
of course in
well, I
Polmear,
agree.
Master Cook didn't accept because he was following Chamberlain J, who held otherwise. But it is a pointer, I think, the time constraints on this different point of the shocking event. It's by analogy. And so, my Lord, I will come on to the brief facts of Polmear, which you may well have assimilated in any event. They are found in paragraphs 2 to 12 of Master Cook's judgment, bundle A, pages 217 onwards. And his summary of the facts is importantly taken directly from the particulars of claim, where the events giving rise to the claims are set out under a discrete heading. Bundle B, pages 131 to 134, paragraphs 5 to 15 of the particulars. The master goes on to describe and set out the circumstances of claimant's daughter's death, but I don't think, for present purposes, sad though they are, you need to be overly concerned with those on the issue for decision here.
Miss Jones,
My lady.
I'm sure we just all want it to be understood that we have carefully read the papers and read the circumstances of each of these cases.
And you will have read the master's decision at first instance.
Oh, yes.
4 main findings bound by Chamberlain J's decision. Clearly actionable damage prior to Esme's collapse and death on the 1st of July. And this differs from the case of Paul, where it was pleaded expressly that the heart attack was the first manifestation of any injury to the primary victim. And the contrast here is that we have the pleaded case under the heading events of earlier damage, earlier symptoms. It wasn't simply a finding that she'd suffered actionable damage, but between mid-January and the 1st of July, the learned master found that the symptoms suffered were sufficient for a claim to have been founded on her behalf. Paragraph 38 of the judgment. So her actionable damage was at a point months before the relevant event relied on to found the secondary victim claim, her subsequent collapse and death. And there may be an issue in the case when my submissions are responded to, but what we say that as described in the particulars of claim, these were not merely transient symptoms, as the claimant had argued, and that was a finding by Master Cook. They were not merely transient, they were regular and extremely worrying to both parents. That was the second finding. The third finding, perhaps with some prescience, the master held there was a danger of submitting the facts of appellate decisions such as Walter's to detailed scrutiny, as each case must turn on its own facts. Paragraph 40. And then at paragraphs 42 and 43 of his judgment at pages 225 to 226, the master went on to decide to reframe the argument on the basis of the evidence that of course was unchallenged because it was a strikeout application. And his reasoning was as follows. Esme's collapse was a sudden event, external to the secondary victim, and he accepted it led very rapidly to her death and would have been horrifying. The fact that she'd suffered non-fatal episodes, as he'd found, prior to this event was not a bar to her recovery. Because the final episode was a fact and consequence of the defendant's negligence. And fourthly and finally, it wasn't necessary to identify a stopping point, since it was possible...
So sorry, these are you reading from somewhere? Or
I've summarised his reasons in paragraphs 42 and 43 of his judgment,
Yes, I see. Okay, thank you.
which is at A225.
No, I've got it. I just thought I was
No, I'm
trying to
just
find the
summarising
passage you were
the
reading, but you weren't. You're
main
summarising.
findings.
Okay.
So the final episode was a fact and consequence of the negligence, and he held it was not necessary to identify a stopping point, as had been canvassed by Mr. Justice Chamberlain, since it was possible to identify a qualifying shocking event, and this didn't need to coincide with or precede first actionable damage to the primary victim. My Lord, the submissions in the Paul appeal made this morning and this afternoon are very similar and very relevant to this appeal, and they are relied on in full. And to the extent that those grounds of appeal which have been covered, have already been covered by Mr. Baggett, they are not repeated here. But the additional factor is the evident actionable damage, which the defendant contends should have been a bar to a second victim claim based on a later event. In summary, we say, to hold that the final episode, the collapse and death of the primary victim, was the event on which the secondary victim claim could properly be founded, was contrary to the applicable principles in Taylor and Somerset and Taylor and Novo. Properly analysed, the horrifying event on the 1st of July was simply a further and final consequence of the breach of duty months earlier, with Esme's symptoms unfortunately having continued unabated as a result. And we say that proper consideration of those two cases, the two Taylors, would have provided the correct outcome in this case and resulted in a decision that the claim was unanswered. The reason for that is it is not enough to show that shock was a consequence of the negligence. The proximity requirement involves more than whether you can ex post facto trace a causative link or indeed foreseeability back to the breach of duty. Putting it another way, a mere causative link between the breach of duty and the death is not enough. So the accrual of the primary victim's cause of action months earlier is the fact and consequence of the negligence. And it isn't rendered irrelevant because of some later consequence that is shocking. It is of paramount importance in that it would preclude a claim being brought on the authority of Taylor and Taylor for a psychiatric injury to a third party resulting simply from the later consequence. And you cannot choose a later time than the fact, the breach, and the consequence, the damage, without falling foul of the control mechanism for proximity in time and space between a tortfeasor and a secondary victim. So if that is right, you don't get to the second legal proximity case. If I'm wrong on that, you do, and then it is a general consideration of legal proximity. Putting it in another way, there has still to be a close nexus between the incident or the tort suffered by the primary victim and the secondary victim's experience of a horrifying event. If you haven't got that nexus, the claimant cannot overcome the hurdle of proving proximity to the negligence.
This is all about time, isn't it? Because there is clearly a nexus here. The negligence caused the injury and ultimately the death. What closer nexus do you want? But your problem is it did so and the death and therefore the injury to the secondary victim. Your point is it did so too long after the event.
It did, but also when there'd already been, not describing it as an event, but negligent infliction of damage to the secondary victim, which the...
Speaking myself, I have not understood at any point in this case why any of that is relevant. Your main point is about time, isn't it?
That is my main point, but the secondary point is that if you've got the negligent infliction of damage, that is the stopping point, and I think that is accepted by the respondents in the Paul case. We'll hear tomorrow if that is the case, but certainly upon their skeleton argument, if you've got negligent infliction of damage, that is the cut-off point, and following that, a secondary victim cannot bring a claim, even if there's a causative link, even if it was foreseeable, because the cut-off point has precluded that.
And there's no authority for that proposition, is there?
Well, it's effectively translating the two-event case in Taylor to two clinical negligence injuries, if you like. the event of the suffering of the negligently inflicted damage and a subsequent
It
event.
would be quite absurd, wouldn't it? Suppose there wasn't otherwise a problem about time. Suppose on day one, a child first manifests an injury, manifests some physical injury, as perhaps a minor fit, which is not particularly distressing. The very next day, they have an absolutely shocking fit and then die, and the parent is present for both. It would be ludicrous that if the first one hadn't happened, they could claim, but because 24 hours earlier there had been sign of some other injury, they couldn't claim. How could that possibly make any sense?
That is the effect of Taylor. And
Is
that
it?
is-
Well, I don't see you.
But
Taylor
that
and
is-
Somerset or Taylor and Taylor and
Taylor and
Noble?
Novo.
Well,
So two events. That is the
I
point.
don't see it myself.
Okay.
But there we are.
Was not what he said.
Yes.
Well, even if suppose you're right, that it's the effect of Taylor, do you accept that it's absurd?
With respect, in the field of secondary victims, no, because it is the tight constraints that are important here. And there are difficult decisions. You could say it's absurd that somebody who comes to a mortuary an hour, 3 hours after the body is delivered there isn't exposed to a sufficiently shocking event as they would have been 3 hours earlier if they'd seen the beloved one in the throes of a ghastly epileptic fit. I mean, it's cases fall either side, and there are hard cases, and cases that just get past, and cases that clearly get past. So I think absurdity with respect is putting it too high, and there are requirements that mean that there are hard cases as well as straightforward ones. And there is the point that you could have a continuum of breach of duty, which would allow ongoing treatment between the day of the first less horrifying injury and beyond an ongoing duty to treat, which might overcome your point that it would be absurd. But if it is right, as it is submitted by the respondents in Paul, that the first action damages the cut-off point, we get home on that with respect in this case. The claimants now, just if I can address this point, there is some significance in this point of actionable damage, because it now appears that the claimants seek to overturn the finding clearly made by Master Cook of prior actionable damage. The reference to that in the claimant's skeleton is at page 15455F. I can deal with that either in response or now, but it's...
Well, is there a respondent's notice?
There is a respondent's notice seeking
On that
to
point.
rely...
On that point?
On that point, my lord,
Okay.
yes. And what it seeks to rely on is not the same or additional grounds or different grounds, but a different ground which is the exact opposite of the reason. So it's
Well, why don't you deal with the respondent's notice in reply, which
All
is
right.
the normal place to deal with them.
Very well. So I've dealt with the stopping point. The fifth ground is the same as in Paul. If the master's approach was right in this case, it would allow the secondary victim to be able to claim, and this is my lord's point, months, years, decades after completion of the tort, even when ongoing actionable damage has been suffered for the whole or part of that period, providing causation was made out. And that would permit a significant, and in my submission, impermissible relaxation of the strict control mechanisms imposed by the courts. And it's a point made by the claimants about fairness and what the ordinary reasonable person would regard as fair between different classes of claimants. This is, with respect, not about whether the Polmears or any other bereaved or injured relatives are deserving. If a sympathy test was required, none of the claims could be defended. and Lord Ackner in Alcott makes that point. But that is not enough. And if the only requirement is an event caused by the defendant's negligence, which this would amount to years, decades down the line, that this is not the right test is demonstrated by Mrs. Justice Hallett, as she then was in White and Little, where she says at C362, paragraph 42, to accede to the claimant's arguments would be tantamount to saying that provided a claimant can establish a causal link between their injury and the defendant's negligence, they have a claim. This is not the law and never have been. The claimant must establish a duty of care, must establish the legal and factual proximity. I'll turn next, conscious at the time, my lords, and my lady, to purchase. And the structure of my brief submissions on those will be...
I mean, I'm just... I can't see why you're dealing with purchase in advance of the appeal being opened. I mean, isn't the
Yes.
normal order that purchase should go first and you come back with your reply to purchase and then there'll have to be a reply, I mean, your answer and then there'll be a reply, but...
Well, I'm relieved in a sense, my lord, but I think it came from the...
well, I know,
that we would deal with
well,
the
because
cases.
we anticipated, I mean, I'm speaking here probably for others, but I think we anticipated that purchase would be very similar, but let's have them open it, and then you can...
Unless I can assist your lordship, my lady further, those are my submissions on the...
Yeah, okay, yeah, I think that's better. Thank you very much, Mr. James. Mr. Weir.
Well, may it please your lordships and my lady. My lord, I'm obviously anxious to address right at the outset the claimant's case in response to the various and detailed submissions or observations, I should say, of the court.
We haven't made any submissions, Mr. Weir.
No, my lord, simply an error, of course, observations of the court. My lord, can I start addressing them in this way, outline and then try to make good the submissions that I make? Of course, it's the case that the court is concerned with the existence of a duty of care owed by the defendant to the claimant's secondary victim. Further, that duty of care is analysed by reference first to reasonable foreseeability, which for the purposes of this strikeout application has been passed, and secondly by reference to what's known as legal proximity. So that in that sense there can be no doubt that the court is at heart concerned with the single question whether there is legal proximity made out between the Defendant NHS Trust and the claimants. But that is not a question which sits there in splendid isolation or with additional impetus attached to it to the further question that then arises, which is this: in the context of secondary victim claims, legal proximity is addressed by reference to the control mechanisms.
And only by reference to them.
And only by reference to the control mechanisms. The difficulty which has arisen between, on the one side, the observations of my Lord Master of the Rolls, and on the other, at least the earlier observations of my Lord Justice Underhill, is that is question begging as to what is meant by reference to the control mechanisms. And the correct approach in our respectful submission is that the control mechanisms involve not only issues such as the need for a recognisable psychiatric illness, closeness in time and closeness in space, but also the correct identification of the relevant event. I do not shy, my lord, from using the word event. It is a word, as I'm going to show in a moment, which has been employed in this area of the law from McLaughlin. And so whilst understanding in its...
So what is the event? how is the relevant event defined?
My lord, yes. The relevant event is defined as follows. First of all, there can only be a single trigger or event. Secondly, that event is the damage which it was the defendant's duty to protect the primary victim against.
Sorry, just slow a minute.
Sorry, my lady.
No, the damage which it was...
Damage which it was the defendant's duty to protect the primary victim against when it first becomes manifest or evident.
Hang on, we're going to take that a bit more slowly.
Yes, my lord.
The event
Yes, my lord.
is the damage that it was the duty of the defendant to protect the primary claimant from,
Victim, my lord.
primary victim from,
Against when it
Against.
first becomes manifest.
sorry, when it first becomes manifest.
My lord, yes.
When what?
When it, the damage.
When the damage first becomes manifest.
Or evident.
Sorry, you dropped your voice.
Or evident.
Or
Just
evidence.
Or evident.
Yes.
Is there a difference in manifest and evident?
No, my lord. In my respectful submission, I'm going to stick with manifest from here on in.
So let me just read that back to you because I want
Yes,
to make
Lord.
sure I've got it. That event is the damage that it was the duty of the defendant to protect the primary victim against when the damage first becomes manifest or evidenced.
Evident.
Evident. Okay.
My lord, yes. The easiest way of...
And do we get that out of an authority?
My lord, we do, once it is understood that Lord Justice Ward, when he referred to when damage was first inflicted, was referencing when damage first became manifest, which is how Mrs. Justice Swift so interpreted it in the case called Shorter. It is of a piece
Sorry,
with...
I just want to take that a bit slowly as well.
Yes,
We
my
get that out of Lord Justice Ward when he said when damage was first inflicted, meaning when damage was first manifest.
first became manifest, my lord, yes.
And that came from Swift J import in
A case called
Shorter.
A case called Shorter, my lord. But of course, I can go to all the references, but I'm seeking to address
No,
right
no.
at the outset
no, it's helpful to know what your
our
submissions
case
are.
rather than get lost in authorities straight
Yeah,
away.
Mr. Ware, we encourage people to tell us what their submissions are.
So my lord, can I seek to apply that first of all to the facts of Paul, then to the facts of Taylor and Novo to show, in other words, two applications of this test. On the facts of Paul as pleaded, and I can take you through the actual particulars of claim, but again, I'm going to try to sort of move at pace rather than get lost in the pleadings at this point. The case is pleaded expressly on the basis that the heart attack was the first manifestation of damage to Mr. Paul. And it was that heart attack which was witnessed by the claimants and which was shocking to them. So there is an ordinary application. In Taylor and Novo, the falling off of the shells onto Mrs. Taylor caused observable injury to Mrs. Taylor. In other words, the damage to Mrs. Taylor became manifest at the time she was struck and hurt by the falling rack.
So that's your distinction.
Lord, yes, it's very important because, and obviously I will proceed with care, seeking to support every submission I make, but the observations in relation to Taylor and Novo certainly do not marry with the submissions which I shall be making in relation to what, properly understood, Lord Dyson was intending to achieve by his judgment. What Lord Dyson was intending to achieve was as follows.
Right.
He was rejecting the submission made by claimant's counsel that there can be two or more events. We can call them events or relevant events, i.e. events to which one can attach the shocking experience. And he was recognising, and I will take you to paragraphs which in my respectful submission show this, he was recognising that it was the observable injury to Mrs. Taylor that qualified or created that as being the relevant event, and rejecting the argument that that being the event, the claimants could attach themselves, or the claimant in that case, to a later event.
The secondary claimant.
So that the claimant, secondary victim, could attach herself to a later event. That would be going too far. And respectfully, we agree.
Okay, yeah.
The concern in relation to delay wasn't a concern that there is a gap, so much as this claimant, Miss Taylor, couldn't qualify herself within the aftermath doctrine because what she complained about was a shocking, separate, later experience, 30 days or thereabouts, after the relevant event. And that truly would have been to change, using a description of Mr. Justice Chamberlain at a more macro level rather than a micro level, the control mechanisms first established in McLaughlin. Furthermore, and for the avoidance of doubt, the relevant event is not defined by reference to the date of the breach of duty.
Sorry, say that again.
The relevant event is not defined by reference to the breach of duty. It does not attach itself to the breach of duty. And we'll take you through references in McLaughlin and Alcott, but can I start on that with working examples? Your Lordship and your Ladyship have considered the stacking shelves of the RSJ, but can I stick with Hillsborough and McLaughlin, so a road accident in Hillsborough. Hillsborough, as we've understood from the various public inquiries, really involved decisions which were careless decisions by the police officers very close in time to the disaster as it unfolded, allowing people in Lepping Lane entrance when it was becoming overcrowded. But what if the decision to let people in had been the product of an earlier protocol set by the police? This is how many were let in, and that was careless or defective. And that protocol, the breach of duty, had been made a day, a week, a month, a
So
year.
the breach of duty would still occur at the moment when they were in fact excessive people let in, even if there had been an earlier protocol.
My Lord, if one was pleading the case for breach of duty, particulars of negligence, one would plead having a defective protocol.
Well, I'm not sure. Well, maybe you would. I would have pleaded it as allowing people in when it was dangerous to do so.
Well, if we
I suspect you'd fudge it and say it was a continuing
My Lord,
breach.
what's important here is to set out how breaches of duty, in a very ordinary fashion, can take place far removed in time.
Of course they can.
Well, that we accept.
So-
I
so-
don't have
so-
to argue
so-
about
so if
Hillsborough.
if
It's
that-
not
if
really
that- if
on.
Can you answer one question for me?
Yes, ma'am.
Take, humour me, Mr. Ware. Take the RSJ, right? I like the example
Yes,
because
sir.
it's very simple.
Yes, ma'am.
It was designed negligently by an architect, and the damage takes place years later. And at that stage, C1 is fatally injured and C2 is watching. Can C2, under the principles you've submitted, are the correct legal principles, claim?
Absolutely.
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 Thank
We
you.
have no hesitation or embarrassment whatsoever in recognising that there will be many cases when the breach will go back. If we take the road traffic example, a tyre could have been put onto the car carelessly by a garage a day, a week, a month before. In the Court of Appeal last week, in a case that my lady may or may not recall, she wasn't sitting at that, but gave permission, I was pursuing a claim for carelessness and negligence by a highway authority in the design and construction of a road in 1967, giving rise to a road traffic accident in 2017.
Did you win?
My lord, it's a strikeout, but sorry, I don't know. In relation to that issue, the only point being taken was a pleading point that the case hadn't been sufficiently pleaded. There is no difficulty. This is an ordinary
Time doesn't matter.
an ordinary instance of common law negligence that sometimes the breach will be coterminous with damage.
So time doesn't matter.
Time.
Mr. Baggett says time is everything. You say time doesn't matter. It's about the question of proximity, and you can be sufficiently proximate whatever the time.
My lord, this may sound like a forensic or jury point, but you say Mr. Baggett says time matters. Mr. Baggett says time matters to you under considerable pressure from the court.
Well, it was my lord, not me.
I never use any pressure at all.
And I think that's most unfair.
Well, my lord, I mean,
No, any pulling your leg.
Force of personality, my lord. But that is not the submission which he made. Indeed, he was at pains to make clear that he was not making that submission before Mr. Justice Chamberlain.
Right, where do you see that?
See paragraphs 53 and 63. 53, page 205 of the core bundle.
Yes.
Sorry, just give me the
Yes, my
paragraph
lord.
again.
Page
63.
205.
No, 63 is good.
53, and then, but that's 53. We'll go to 63 if we may, my lord. We'll start with 53. Mr. Baggett submitted that the respondent had never argued, and the master never said, that a gap in time between the breach of duty and the consequent shocking event precluded a secondary victim. See para 63, page 207. Follows from the foregoing analysis the key question in the present case whether Mr. Paul's collapse of a heart attack 14.5 months after the allegedly negligent treatment is capable of constituting a relevant event. There are three possible reasons why not. The first is that the event has to be synchronous or approximately synchronous with the negligence which gives rise to it. And it's clear that there Mr. Justice Chamberlain is using the word negligence, as can happen somewhat colloquially, to mean breach of duty.
Mm-hmm. And that Mr. Baggett was at pains to emphasise that he'd not advanced that before the master and was not advancing.
Correct, my lord. But he succumbed to the pressure because, of course, it's so tempting when one can concur or agree with the observations of no less than the master of roles, which may provide a route to success, to do so. But he had no real intention of doing so. And if your lordship were to continue paragraph 63, you'll have yet more working examples given by Mr. Justice Chamberlain of how, and I use with care, it's a word which has been used by my Lord Justice Underhill, but how it would give rise, frankly, to absurdity. But it's not just absurdity, it's unfair. It's gross unfairness if breach of duty was the touchstone. Because you can see that, as Miss Johnson, my learned junior, submitted, I'm over the page, my Lord, there's nothing in any of the House of Lords authorities considering the control mechanism suggests a claim for psychiatric injury suffered as a result of witnessing a person's death or injury caused, for example, by the collapse of negligently erected scaffolding, which sounds remarkably like the RSJ case that your lordship has been promoting, or electrocution as a result of negligent wiring, be affected by the date of the negligence. That's negligence again, meaning breach of duty.
Well, he then says Taylor and Novo does not suggest that it would. In that case, Lord Dyson made clear at 29 the secondary victim would have been able to recover if she had witnessed the accident with the racking boards. But that's not really... that's not really the same point, is it?
There's a language issue. It's not. It's what happens. People flip not only between negligence and breach of duty, but between accident and injury. because of course in an ordinary context,
Yes.
road traffic accident,
Normal
accident.
people, normal
We don't say
people
road traffic
don't
injury
distinguish, and why
in
should
our personal injury world. We
Yeah.
call it personal injury, but we don't say road traffic injury. We say road traffic accident. And so there was an accident, but in the ordinary, indeed, as correctly observed by Lord Dyson, paradigm. The paradigm in personal injury is that of a breach of duty which gives rise to observable injury, say road traffic accident.
When we look at the early cases, we'll see that nervous shock was a concept that originated from instantaneous events where the negligence and the damage to the primary victim were contemporaneous or fairly close to contemporaneous. But you say that did not reflect itself in the control mechanisms laid down.
My lord, I do say that, and can I take you first to McLaughlin? Take me please to page 41, we're going to be in the judgment of Lord Wilberforce. And I understand and recognise the force of the observation by Lord Justice Underhill. One has to take great care as to quite how much one invests in particular sentences from the Law Lords in these two highly important cases. But with that proviso, can I go to look at particular words of their lordships
I'm going to do so.
in those particular cases? Page 41, the sidebar passage at B, which I'll pick up as so it's my lord. It's page 41.
41 in the bundle.
41 in the authorities bundle.
Yeah, got it.
Your lordship should be in the judgment or opinion of Lord Wilberforce in McLaughlin.
41.
At page 41b.
Mm-hmm.
To state therefore a rule that recoverable damages must be confined to persons on or near a highway is to state not a principle in itself, but the only example of a more general rule. That recoverable damages must be confined to those within sight and sound of an event caused by negligence. Now, howsoever you describe negligence, if negligence is breach of duty, it's certainly looking at the least at your injury. And of course, if negligence is breach of duty and injury giving rise to the completed cause of action that we know as negligence, it can be something later. So that is, and that's using again, right at the outset, and I'm afraid, my lord, it's unavoidable, the word event. And it comes as part of what we would call the control mechanisms. And so has always been understood.
Well, the most obvious, the reason why the word event is necessary, to me it seems the only useful use of it, is to describe the thing which produces the nervous shock.
My lord, it's difficult to know quite how to answer that question. Yes and no, in that, my lord, we're not supposed to be working backwards at this point and saying we've got a case of nervous shock, so we're going to call that which caused the nervous shock the event. We're supposed to be working forwards and saying let us identify the event. There has to be an event, and this is why it may be, if I might respectfully make the submission, something of a language issue debate between my learned friend on the one hand and early on at least my Lord Justice Underhill and the Master of the Rolls. Because whether one says there's something additional to control mechanisms depends on what you mean by the control mechanisms. But if you recognise the control mechanisms involve analysis of what constitutes the relevant event, then it's the control mechanisms. Either way, you have to address that question. You cannot avoid that question. That's the question that lies at the heart of the appeal. And that's a question that right from the outset you see being asked by the House of Lords. So when the Lord... If your lordship kindly goes over the page...
Well, you'd be on a very strong ground if nothing had happened since page 41b.
Well, my lord, things have happened beyond page 41b, and I'm fully prepared to address them in turn. But can I...
No, but I mean, I understand precisely what you said about
But can I go to page 42?
Yes.
Get there in stages, my lord. Page 42 at D. As regards proximity to the accident, it is obvious this must be close in time and space. After all, it is the fact and consequence of the defendant's negligence. So again, we're looking at fact and consequence of the defendant's negligence that must be proved to have caused a nervous shock. And then you see reference to Benson and Lee, and of course there we have again our friend, direct perception of some of the events which go to make up the accident as an entire event. If your lordships and my lady kindly turn to Alcock, starting at page 1.
Just ask this,
yes,
because
my lady.
I, speaking for myself, I find that phrase fact and consequence quite compelling. Doesn't that feed into event?
Oh, absolutely,
It's
my lady.
it, isn't it?
But this is why he sets out the fact and consequence and then references the necessity to identify your event. You're looking for a single event, and that is when the damage to the primary victim becomes manifest. Why is it that? I'm going to take you in due course to Lord Oliver's opinion, because we are concerned here with the justice that has long been recognised by these courts. You know, way back into the 1920s, when negligence was only in a growth area, it was understood that there was a proper role for the common law to provide a remedy, which we now know as a remedy to a secondary victim. And it started off with mothers and the like, who by direct perception witnessed, say, their child being knocked over by a horse or the like. But the common law recognised this from the outset. So yes, the word exception is used by Lord Oliver, but the two have actually run together. When looked at on a broader canvas, Donahue and Stevenson marking the seminal.
I'm old enough to remember when I studied the law, Mr. Ware, there were articles written in the learned journals about the nervous shock cases and massive disagreement academically about whether they were right or wrong. And this was, I regret to tell you, sometime before McLaughlin.
Well, my lord, yes. Well, my lord, it's been rumbling on, but actually the law has developed, and we're going to see this when, for instance, you see the observations of Lord Justice Clark in Walters, that it's very easy to think the law is shut down by brief reference to Lord Hoffman and Lord Steyn in Frost, and that's not what they say. And I'll go to that in due course.
Right,
but
so you say that, you say Steyn,
Yes.
Frost is not a shutting down of the development of the common law.
It's not at all.
No, okay.
There are a number of submissions I have to development on, but I just wanted
Better to give us notice of them.
needed to address issues like this straight at the outset. So if the court then kindly goes on to the Alcock decision on page 161.
Now, the only judgment speech in McLaughlin that we are concerned with is that of Lord Wilberforce.
It's the only one to which I'm proposing to take it.
Can we assume that everybody is to be taken to having agreed with him?
Well, I don't think it's a question. I don't think it's a question of everyone's been taken to agreement. I think it's just one of those things where history dictates that the judgments of some of their lordships have been to have stood the test of time in exactly the same way as Lord Oliver's opinion hasn't been endorsed expressly by the other law lords, and yet it's to Lord Oliver's opinion that one turns.
Okay, and same with Lord
For what it's worth, I have certainly seen, but I couldn't tell you where, some references to Lord Bridge's judgment.
Yes, Lord Bridge does address.
I'm not necessarily saying you should take us to a particular passage, but I don't think it can be overlooked, whereas I think that'd be rude. I think Lord Edmund Davies's Starman probably can.
Well, one has to take some care because it's 1983, but if, for instance, at page 61, between D and E, you were to look at the speech of Lord Bridge, you'd notice the passage that starts a policy which is to be relied on to narrow the scope of a negligent tortfeasor's duty must be justified by cogent and readily intelligible considerations and must be capable of defining the appropriate limits of liability by reference to factors which are not purely arbitrary. In other words, rather the other way round. Now, we recognise now that the burden's always upon a claimant. If we're in a world of new law, which we say we're not even applying, we say, the incremental approach to this, we're in established law, but if one were in, then certainly at the time of Lord Bridge, he rather saw the burden as resting with the defendant to explain why you should hold back from establishing a duty of care. He also identified over the page how the floodgates argument has been greatly identified.
Greatly exaggerated.
Sorry, greatly exaggerated. And then over the page again at 63, this is still applicable guidance. At B, I've no doubt this is an area of the law of negligence where we should resist the temptation to try yet once more to freeze the law in a rigid posture, which would deny justice to some who, in light of in the application of the classic principle of negligence derived from Donahue and Stevenson, ought to succeed. And then lower down at D, you should have regard, and this is a passage which was quoted approvingly by Lord Justice Ward in the Walters case, where in a particular case the good sense of the judge, enlightened by progressive awareness of mental illness, decides. So yes, my lord, there are some...
Sorry, where is the good sense of the
Yes,
judge?
my lord, it's
Oh,
right at the end.
Yeah,
It's
where
also
is it?
sidebarred, my lord.
Mhm.
Apparently attributed ultimately to Lord Wright. Yep.
And applied in Walters. So, if I can then take you please to Alcock and to the speech of Lord Oliver at page 161. At E, that's page 161E, starting broadly. Broadly they divide into two categories. Does my lord see that?
Yeah.
161E.
Mm-hmm.
Divided into two categories. That is to say, those cases in which the injured plaintiff was involved either immediately or immediately as a participant, in other words, a primary victim, and those in which the plaintiff was no more than the passive and unwilling witness of injury caused to others. Two parts to that. First of all, of course, the focus on injury. And secondly, yes, as a matter of common sense. Common sense is prayed in aid, both in McLaughlin and in Alcock by the law lords. Why is that a matter of common sense? Because what is a secondary victim claim all about? It is all about recognising that there are a group of people who will be put in a position, unwillingly, where they witness a shocking unfolding.
Yes, it's not very shocking to look at somebody swerving their wheel negligently. That act is not normally horrifying. What is horrifying is the cause of having swerved the wheel and the injury to people, which will always be loss, will always be damage.
My lord, yes, always be damaged.
Yeah.
Otherwise, you might as well say, and this sounds facetious, but are we going to attach it to staring at RSJs, which are defective, albeit one wouldn't know it? No.
Yes, the act of designing a negligently designing an RSJ is unlikely to itself be horrifying,
Well, no.
except perhaps to a very, very clever engineer.
There are those of a sensitive disposition, my lord, but as your lordship will know in this area, one needs to apply so-called ordinary phlegm.
No, I get all that. So you say,
But my lord,
really, the whole thing must be about
it makes
that.
sense. That's the point.
Mm.
It makes sense because one should start, and I was planning to take the court through references to what's the search for what's right, fair, and just as a matter of common sense, which I will hope to do later, in these two very important judgments.
I thought that had gone out of fashion now.
Well, my lord, it hasn't gone out of fashion in relation to this area because, of course, when we say legal proximity, you have the references. I think it may even be Lord Oliver in this case, in which it's well understood that the sort of legal proximity, what used to be described as fair, just, and reasonable, all sort of come together. Of course, we look at incrementalism. That's the proper interpretation of Caparo, C. Robinson. But we are, or I say we, not me, my lord, those in a position of power, namely the court. The court is charged with responsibility for developing this area of the law, if development's even needed, in a flexible, coherent, and fair way.
And you say the fact that this area of law was developed in accident cases where immediacy between the immediacy between the breach of duty and the damage happened to be always the case is absolutely nothing to the point about the scope of the remedy.
My lord, it's nothing to the point in that once one remembers what this area of law is all about, which is designing a remedy in an appropriate case for a person who witnesses harm to their loved one, of course the focus is on one, the harm, and two, when the harm becomes manifest.
And I get all that. How do you get over the suggestion that Lord Dyson undoubtedly made that that it would be going too far to find that, as a matter of law, effectively it was proximate, that the defendant had a proximate relationship with the secondary claimant injured years afterwards? I mean, I'm saying years afterwards, he didn't say that, but long after.
My lord, the concern of Lord Dyson has to be seen in the context of what was before him, and what was before him was the argument that it doesn't matter that we've got damage manifesting here, I can select out an additional event of my choosing.
Right. So, but then in every case, I mean, let's assume you're right about that construction of that case. In every case, we'll be looking, won't we, for the first sign of damage.
First manifestation of damage, and that sorry, my lord.
No, I'm sorry. I must let you finish your exchange with my lord.
That operates as a break or control on the ordinary concerns. I say ordinary meaning we recognise the validity of the court's concern throughout in an area like this, so floodgates concern, etc.
But I mean, it's not just a question of floodgates. It adds huge complexity to the cases.
My lord,
Perhaps I can come. I mean, speaking for myself, I've not understood where this whole first manifestation doctrine, I haven't understood where it's come from in the case law, but you're going to show us that. And B, why it's desirable, why it's a necessary part of your case. Is it because you feel in the case of Paul at least that you can satisfy it, and therefore why not, and help reassure the judges they won't be opening the floodgates. But from every other point of view, I'm not sure it'll help all the other claimants as much as you. And why is it necessary? It would produce ludicrous and very expensive analyses. Oh, well, yes, but there was this terrible event on day one. But look back on day -2, she showed a rash, and therefore you can't rely on what happened on day naught. It's not the way the law should go.
Well, my lord, respectfully, the analysis of the Court of Appeal leads the way in the case of Walters.
In the case of Walters, you say you. Well, can I just take this in stages?
Yes, my lord.
If there was no authority,
yes, my lord.
So you didn't feel this was an issue with which you had to grapple, would you submit there was any principled basis for a first manifestation only rule? And if so, what was it? What is it?
Yes, my lord. Because the tenor of the judgments in McLaughlin and Alcock directs the court to ensure that there is some control, hence the later use of the description control mechanisms, some control over the determination of duty of care in the context of secondary victims.
But there is control. Shocking event.
Yes,
a very
close
close
time and
relationship.
space.
And
Close
time and
relationship.
space to the shocking event.
Recognised
Those
for
are the control
psychiatric
mechanisms that were thought to be good enough in the all happened at the same time cases. Why aren't they good enough in the happened 6 weeks, 6 months later cases?
Well, I understand that there may be others before this court who wish to immediately adopt that observation because it may or may not be necessary in their case. And I understand that certainly my principle is never go further than you need to in relation to any case.
So your position is you're not particularly seeking to defend this, but you can, you say you can meet it on the facts of your case, at least at the strikeout stage, and therefore you are not going to argue for any more principled approach.
Well, my lord, no. That was a preamble.
Oh, sorry. I should have let you get on.
And more
Jumping down your
cynically,
throat.
lets you get one way round Lord Dyson.
But Lord Dyson, it's identifying the ratio of a case. I suspect is again. I mean, I'm not saying it's not important because it's obviously important. But listening to the observations of this court, I'm quite wary because it seems that there's scope for a lot of different ways of presenting the ratio of a case. And I don't say the argument would be.
We could say essential decision if we didn't want to use Latin and we wanted people to understand what we were saying.
My lord, yes, which would be helpful. But I don't say it would be arid to do that. But I'm just cautious before entering that arena and put that flag up. But from my perspective, what the essence of Taylor and Novo is there must be a single event. Because what Lord Dyson is rejecting is the argument I can pick a second later event.
Okay, so is it fair to characterise your position as being you're forced into taking this position because otherwise you've got a problem on your reading of Taylor and Novo? Which, there's nothing irresponsible about that. You've got to deal with the authorities
I've got
as
to
they
deal
are.
with the authorities as they are, my lord. That's Taylor and Novo, and that's what it says. We always reserve our position for a higher court if we need to, but that's our position. We also have the...
Okay, but that's helpful to me because I haven't really, I've no doubt been very slow. The real reason why this whole doctrine of the first manifestation has come in is effectively defensive as a way of distinguishing Taylor and Novo on one reading. Otherwise, there's not much to be said for it, is there?
Oh, my lord, it depends whether you wish me to sort of say all from a claimant's perspective or trying to briefly
In a way that will
stand in
persuade
the
me.
shoes of the court if I'm allowed to be so
Well,
bold.
you're allowed to make whatever submissions you want, which will help your clients.
No, but my lord, just why push further than is necessary
Yeah,
in an area in which I recognise the courts wish to retain control over secondary victim claims. That's probably the best I can say in relation to that issue, and don't need to go further. I also recognise that in Walters, actionable damage occurred prior to the 30th of July when the seizure started. Exactly materially the same as occurred in Poole. And that is because both are cases of clinical negligence by omission, failure or delay in treatment, however you wish to describe it. And it is inherent within a claim based upon an omission to treat in order to succeed on causation that the claimant says, but for your negligence, the primary victim would have been treated and the shocking event which unfolded would not have taken place. So it is inherent in both Walters and in Poole that there was actionable damage prior to the relevant event. And that is why the focus of the court is on the first manifestation, and that is why, in response to the observation of the Lord of Justice Underhill, which I never completed, I was going to take you to paragraph 34 at page 330.
Paragraph 34 of what?
Of Walters, at page 338 of the bundle, please. So tab 10, page 338, para 34. And my Lord Justice Underhill had made the observation to the effect that this is either unworkable or not an attractive position to be in, where the court has to go rooting around looking for the material damage. But actually the court does have to go rooting around in this sense. What is required, exactly as my Lord, as Lord Justice Ward says, is in my judgment the law as presently formulated permits a realistic view being taken from case to case of what constitutes the necessary event. That's exactly what's required. And sometimes it's lovely to have a bright line rule. Now we have a bright line rule in that I've sought to set out, if the court is minded to agree, what I define as the event. That's a bright line rule. But the application of that bright line rule does involve, and it goes back to the echo of Lord Bridge in McLaughlin, the good sense of the judge in identifying, taking a realistic view. So
but this was a different point in Walters. In Walters, the problem was, this may sound a rather cold way of looking at it, that the baby there wasn't a sudden traumatic event. That was what was. They were dealing with a different question.
Well, I understand, my lord, and we've never shied from saying that the issue of two events was not argued in Walters, but actually Walters is correctly addressed in Taylor and Novo by Lord Dyson at his paragraph 35, when he says, in the Walters case, the court had to decide what was the event for the purposes of establishing a right of action as a secondary victim. Page 439. What was the event? So it did have to go to the issue, what is the event? It had to determine what was the event. And it determined that event, lasting over 36 hours, was the period of time starting with an epileptic seizure, which epileptic seizure occurred, A, after actionable damage to the primary victim, and B, after the primary victim had continued to be, open inverted commas, see paragraph 2, very ill, as a result of which he was back in hospital before the 31st of July. The court nips back to page 324.
Just remind me, I ought to be on top of this by now. When was the relevant negligence in Walters?
My lord, the
relevant breach of duty.
There's an issue between the parties as to that. The baby Elliot went in on the 17th of July, and from that time onwards there was a failure. See paragraph 2 at page 324. Your Lordship, see pretty much in the middle of paragraph 2, it's accepted by the defendants he was not properly diagnosed or treated by the Prince Charles Hospital. Your Lordship, see that? In the middle of para 2.
From the 17th of July.
From the 17th of July, and right in the middle again of para 2, the defendants also accept that if Elliot had been properly diagnosed and treated, he would have undergone a liver transplant and would probably have lived.
And when was the 36 hours?
Started on the 30th of July, see paragraph 3. And paragraph 2, four lines up from the bottom. On the weekend of the 26th of July, he was brought back to hospital. So he went into hospital. He was then released. I mean, of course, he shouldn't have been. He should have been sent down to King's College London for a liver transplant. And we know it should have been at King's College London, because if you go to the bottom...
But the key point for our purposes is that there was no pleaded negligence in the period from the 26th of July onwards, and in particular over the 36 hours from the 30th to the 31st. Is that right?
I mean, I struggle to remember the pleadings in terms of exactly what was pleaded, because it may have just been put...
Of course, there's been a
Charles
trial
Hospital.
here anyway, hadn't there?
It was determined by Mr. Justice Thomas, but on the basis of the admission of liability as regards to the primary victim, as opposed to tried out with further evidence on those issues. But, my lord, it can be tested in a very straightforward fashion. And I should say that the learned friend doesn't agree with this, and he's right to try not to agree with it, because he doesn't like the outcome of it, which is a recognition that this is a case in which damage was inflicted before the 30th of July. He's trying to resist that because he sees the effect it has on his case. It necessarily follows, because what should have happened is Elliot should have been treated by liver transplant at King's College London. And that all takes time.
So, in fact,
He should have gone up, had a liver transplant.
no,
And he
okay,
wouldn't
but
have,
I'm separating the breach of duty and the damage. The breach of duty occurs after the 17th of July and is no doubt presumably continuing up to a point where it becomes too late.
exactly, my lord. That's
Okay,
why.
let me just take this down.
Sorry.
And the damage, well, it becomes very metaphysical, doesn't it?
No.
The damage
It's not metaphysical, my lord. It's
Well, the damage
counterfactual.
the damage attributable to the failure to treat, on one view, only becomes occurred at the point where it is then too late to do a liver transplant, and the risk to his health becomes.
It's not. No, it doesn't only occur when it's too late. It occurs at the time that, on the counterfactual scenario, the baby would have been made better. In the case of Phelps dealing with educational negligence, and necessarily I can overnight bring this before the court, it was carefully analysed. I forget now which judge, but it was in the House of Lords.
One of them.
Which says it doesn't, in one sense, it doesn't matter because it is the House of Lords. But it was carefully analysed how it's, in this context, what you're dealing with is a failure to make better. Because, of course, you have someone with an illness, and what you should have done is made them better. And when you fail to make them better by a liver transplant, they suffer damage. So it's not that they suffer damage.
Don't you suffer damage instantly because you are a baby without a liver transplant, and therefore you are at severe risk of death, at greater risk of death? I mean, that's a bit illogical because the liver transplant would take weeks to arrange.
Well, the case which was accepted for the purpose of Walters is a liver transplant. That's paragraph 2, my lord.
Yeah.
Right in the middle of paragraph 2. The defendants also accept that if Elliot had been properly diagnosed and treated, he would have undergone a liver transplant and would probably have lived. And that all, of course, has to have taken place before the 30th of July. And that would have taken
And
place.
would have lived, so he would not have died.
He wouldn't have had a seizure.
Beginning of August, yeah.
He wouldn't have had a seizure, that's the point. Because that's how clinical negligence by omission necessarily operates. Learned Friend makes this point with vigour correctly in his skeleton argument in relation to Paul, and then divorces himself from it in relation to Walters, but he cannot do so because it is the same point.
But then I don't quite understand, because then you're saying that Walters was a case where the first manifestation had taken place before.
No, my lord. Manifestation or evident. Manifestation is this idea that you're not going to immunise the NHS Trust in this context or any other defendant on the first occasion in which what Lord Justice Ward describes as the infliction of damage. In other words, it becomes visible, manifest, or evident.
So it could be a little rash.
No, my lord. That then goes to paragraph 34. And the court adopting a realistic view from case to case of what constitutes the necessary event, so that...
But he wasn't... That's a different question. My lord is asking you about this first manifestation.
I understand, my lord.
As you yourself have said, that really wasn't an issue in this case.
I understand that too, my lord. But
So why does 34 help us on the question of taking
because
a realistic view about the event?
That's exactly the correct approach. If you go back to paragraph 2, you'll see over the weekend of the 26th of July, he was brought back to hospital by his parents because of their concerns for him. He was a very ill baby. He didn't recognise his mother or his father. He wasn't drinking. He was irritable and crying.
But the first manifestation question is of a quite different character from the first event question. We've had this problem about when an injury first manifests itself. I can't now remember, you're the personal injury lawyer, not me, but it's arisen in other, presumably in limitation contexts and so on. In other areas of the law, and is always unsatisfactory because it's very difficult to pin down and calibrate. Oh, well, is that sufficiently significant to count as the first manifestation? And with a complicated clinical presentation, there'll never be a right answer.
My lord, in Renane, which is another Court of Appeal secondary victim case which failed for want of shocking event, in that case there was a botched operation. I think a clip was left in the primary victim's stomach. The primary victim suffered the beginnings of sepsis. In other words, was ill for about, I think, 10 days before then experiencing what I would describe as manifest or clear worsening of his condition. I think it was that way round. or maybe her condition. And both at first instance and in the Court of Appeal, there was no issue over that was the event. The issue was whether the issue was whether the defendant.
Renee, and I've only looked at how it's been summarised in the skeletons so far and in the
Yes,
in Mr. Justice Chamberlain's argument. But that wasn't a first manifestation issue either. People weren't saying it's too late because
My Lord,
because there were some sepsis symptoms 10 days ago. So, however shocking the final manifestation, it's too late. They were saying the final manifestation wasn't shocking enough, were they?
My Lord, I'm not putting Renane before the court to say Renane is binding. Putting Renane before the court to show the court, in my respectful submission, how in practice this does not cause the sort of difficulties which my Lord is anticipating.
Okay.
Because what it involves are realistic assessments being made by judges at first instance.
I see. Okay.
And those are...
Courts can cope is the line.
I beg your pardon, my Lord.
Courts can cope.
Oh, of course they can, my Lord.
And they're the sort of assessments that they are making in clinical negligence cases. It's part of the clinical negligence case.
My lady is exactly right so to say. In the case of Shorter, at page 503 of the bundle, paragraph 209, so page 503 of the bundle.
Is this Mrs. Justice Swift?
My lord, it is. Mrs. Justice Swift, as the court will know, also had considerable experience in the field of clinical negligence. And she sets out, cases of clinical negligence present particularly difficult problems. The factual background of cases can be very different and often quite complex. The nature and timing of events to which the breach of duties gives rise will vary from case to case. She's recognising this is one of those issues that the trial judge is required to deal with. Over the page at 210. Can the court kindly read paragraph 210? May I make two submissions? The first relates to the first sentence. The first sentence, or second sentence rather, in which Mrs. Justice Swift says, it is, I suppose, arguable that the negligence continued from the point when the wrong diagnosis was made right up to the time of the seizure. Respectfully, in line with the observation of my Lord Justice Underhill, not causally relevant. Causal breaches did not occur right up to the time of the seizure because, of course, it would then be too late to take Elliot to King's College London and to give him a liver transplant. So there is no doubt that the causal breaches stopped prior to the seizure and that the primary victim suffered actionable damage before that time. And secondly, your lordships and your ladyship will see the passage in which Mrs. Justice Swift has understood, we say entirely properly, that Lord Justice Ward's description of beginning with the negligent infliction of damages was the time when the consequence of the negligence first became evident. And she later, lower down, says consequence which became evident and impacted on the claimant.
Yes, but that's directed at a different question. It's directed at the event question, whether we're talking about a sudden traumatic event or something more gradual.
My Lord,
for better or worse, we're stuck with part of the case law.
Respectfully, my Lord, that really is to read remarkably narrowly what's happening here. The court is ultimately concerned, exactly the same way Lord Dyson says in Taylor and Novo, the Walters case was, is what is the relevant event? That's the question before the court. What is the relevant event? You have to identify the relevant event. Whatever observations of my Lord the Master of the Rolls, we cannot get away from the need to identify the event. We must employ that language. It's the language we start with in McLaughlin. This is what is happening, courtesy of Mrs. Justice Swift, at paragraph 210. She says, 211, in the present case, the negligence which gave rise to the claim started on the 5th of May and continued until a week afterwards. And then later in her judgment, para 218 at 506, he gets to the point of saying, it was not a horrifying event. That's page 506, para 218, sidebarred passage, my lord.
Well, you might have to identify the event in order to ascertain whether it's a horrifying event. But do you have to identify the event in order to answer the proximity question? I mean, do we need to look at the formula? What is the best formulation of the control mechanisms that we should be using?
My lord, it's that which I'd taken you to, the sentence from Lord Oliver, and I was going to take you to another sentence from Lord Oliver if we just go back to them. So I think I'd taken you to,
So it's Alcock.
his description at page 161, in which he said, when the plaintiff was no more than the passive and unwilling witness of injury caused to others. And then at page 164, I was going to take you here, but that was that opportunity withered on the vine. If you go to page 164 at H,
Yeah.
if I pick it up just slightly above, only from the circumstances of relationship to prime victim, an exception has arisen in those cases in which the event of injury to the primary victim has been actually witnessed by the plaintiff.
Sorry, where are you? Is
My lady, 164
Yeah, I got that.
H.
H, thanks.
If I read the whole sentence, what's more difficult to account for is why, when the law in general declines to extend the area of compensation to those whose injury arises only from the circumstance of their relationship to the primary victim, an exception has arisen in those cases in which the event of injury to the primary victim has been actually witnessed by the plaintiff. And that's why we have manifest, because you can't have an injury being witnessed unless and until it's manifest.
I've got no problem. That's obviously right.
And so that is the guidance. The first comes courtesy of A, the analysis of the Court of Appeal in Taylor and Novo, that you can have only one, and two, thereby acting as a brake on what no doubt would be contended for was otherwise some form of runaway train. And that if we're in that section of the opinion of Lord Oliver, my lord, may I again, because I haven't yet to get to this point, if the court kindly goes over to page 165, I've yet to actually make good my submission that legal proximity is that which involves the control mechanisms. It all really starts at 164, and it's 164 to 165. So I'm in the speech of Lord Oliver at 164 to 165.
Well, that's a long part. Anywhere are we starting?
Yes, my lord. I'm just getting the pages.
I see. Sorry.
And then if you go to F to G of 164,
F to G.
between F and G, it must, as it seems to me, be attributable simply to the fact that such persons are not, in contemplation of the law, in a relationship of sufficient proximity to or directness with the tortfeasor as to give rise to a duty of care. In other words, here, Lord Oliver is expressly considering the very issue which has been of such concern to my Lord Master of the Rolls in the judgment of Lord Dyson, namely the need for legal proximity. What does he then do? He then goes through and ultimately...
So sorry, which passage were you just reading, which ended duty
yes,
of
my
care?
lord. It's page 164.
Yes.
Between-
164? Oh, I'm sorry.
It's the whole passage is 164 to 165.
Yes, but where was the one you were just reading that ended duty of
164,
care?
between F and G, it must, as it seems to me, be attributable simply to the fact.
I'm still haven't got that.
Sorry, my lord, just under the second whole
Yes,
punch,
okay, I've got it now, thank you.
that such persons are not in contemplation of law. He then goes through how the focus is on the unwilling witness to the event of injury. If you then go over the page, he says in the clearest possible terms, which effectively have been borrowed or applied by Lord Dyson and Taylor and Novo, at the top at B, although it's convenient to describe the plaintiff in such a case as secondary, that description must not be permitted to obscure the absolute essentiality of establishing a duty owed by the defendant directly to him. Very, very point. And how does he then address this? And again, forgive me, I'm not going to invite the court with the time
Well,
pressures.
it's when he says, but also upon the proximity or directness of the relationship between the plaintiff and the defendant. The difficulty lies in identifying the features which, as between two persons who may suffer effectively identical psychiatric symptoms. And then he goes off onto the...
Yes, my lord. And then he comes down at E, and he says, the answer has, it seems to me, to be found in the existence of a combination of circumstances from which the necessary degree of proximity between a plaintiff and a defendant can be deduced. And in the end, it has to be accepted that the concept of proximity is an artificial one which depends more upon the court's perception of what is the reasonable area of the imposition of liability than upon any logical process of analogical deduction. Then in his next paragraph, he sets out the control mechanisms. And these are his answer to the question he's asked himself. And I won't read out the control mechanisms which go down to H, but if your lordship kindly picks it up at H.
These are the 5 that we talk about from time to time.
My lord, yes. And which of course relate to the event, because it's all about, they have to attach to something. This is why I say the control mechanisms incorporate what is the event, or you don't know what they're attaching to. And then he says, does the court see at H, it must, I think, be from those elements, i.e. the control mechanisms, that the essential requirement of proximity is to be deduced. And that, respectfully, is why I say legal proximity in the context of secondary victims is determined by reference to the control mechanisms.
Your case is that Lord Dyson, if to be understood as I suggested to Mr. Bagot, is deciding his case in contravention of the Supreme Court in Alcock.
My lord, were he to have done that,
Were he to have done
that, but he, not least he being Lord Dyson, has not fallen into error.
Of course not, but maybe you're going to tell us about that tomorrow.
My lord, yes.
Are we okay for timing?
My lord, I'm sure we will be.
Can I ask, I know this is a big request, but this is an important case, and it would be useful to me, and maybe my colleagues too, if we were to have a transcript of these submissions.
Yes, my lord.
And I know that we haven't been asked to get one, but I wonder if the parties could commission one.
My lord, yes, it's a case in which all the claimants will be operating on CFAs, in which the Defendant NHS Trust may be invited to pay for.
Well, I'm going to leave you to sort that out.
Pay for the
if you can't
costs.
sort it out, let me know. But I think it will be useful. Well, I mean, see if you can sort it out.
Otherwise, I think, and it may be, I think there's a power in civil procedure rules for the court to.
There is a power, and if we need to use it, we will consider using it. But
my lord, yes, and my lord, apologies, but just before your lordship leaves,
bearing in mind the number of counsel before the court, I guess that there must be some expense in this case somewhere.
my lord, yes, but honestly,
the CFA.
Position is slightly different.
Okay,
That's,
well, look,
that's the ordinary way in which cases.
if it's not possible, let us know in the morning, because we're not going to get it between now and tomorrow.
My lord, can I also just say, your lordship raised the issue of Carnham Meadows of copies if it assists your lordship. It's certainly our position that the court is not materially assisted by the 6-stage test as set out in paragraph 28 in the judgment. I think of I think it's Lord Hodge and Lord Sales. But if the court would like copies, we're more than happy to pass
I'd like them electronically, please.
My lord, yes.
But
I'm sure
Can I have difficulty?
Well, it is a case I've read, actually. I had an
Oh,
interest in
your
it.
ladyship, of course, has read it.
Yes, I've read it
having
too,
been
but I'd still
upheld
like to
in-
look at it.
I have also read it, but I would like a hard copy.
Yes, my lord.
So,
Those will be available, and we'll.
can I, at the risk of I'm not intending to prolong this, but I think it follows from the way in which you made your submission on the 5 control factors, that you at least would accept what I put to Mr. Bagot, but they're not really in this context very helpfully described as control factors. They are criteria or indicia or something like that.
My lord, yes, I'm certainly not impressed by a label be form over function, and what's important is one simply understands that the court is trying to identify those cases in which duty of care should be held to exist and those cases in which it shouldn't, which exercise it should perform flexibly, realistically, and with a whether right or what's fair and just. How one then describes those mechanisms is a matter for the court.
Right.